by Advocate Mpofu. Also to acknowledge and welcome evidence leaders at M46, Advocate Mayosi and Advocate Bauer, members of the media, members of the public present with us in your various platforms, the YouTube and 408. You're all welcome. Just want to make sure that we have our link working. Advocate Mpofu, do you hear us?
Yes, I can hear you. Good morning, Chairperson and honorable members.
Thank you. Thank you, Advocate Mpofu. It means our link is working.
Sorry, I thought it felt like there was an echo on my side. Can you hear me clearly, Chair?
It's very clear, Advocate Mpofu.
Okay, thank you.
Thank you. Thank you, colleagues. As I just indicated that we're the new witness on the stand for us here today. Before I invite Advocate Bauer, just to indicate that I did get a message through Advocate Matlape, Advocate Mpofu, that you're asking for an opportunity to address. Indicated I will do that, just so that you know. Let me now recognize Advocate Bauer.
Good morning, Chair. Our witness, good morning. Our witness today is Mr. Gumbi Chialela, who will be testifying. Are you first going to give Mr. Advocate Mpofu an opportunity to address the committee before we go to the witness?
I was not going to do that. I just want to check, is Fatima online?
Yes, Chair, I am.
Okay. Right. Just be ready. I know I'd indicated Advocate Bauer having received a request from Advocate Matlape about Advocate Mpofu to address, but it's in relation to correspondence that would have been sent to him from the chair, not about the witness. And so I would want to treat those things in that way.
Chair, I don't understand what that means.
Hello?
So, Chair, you're cutting.
Can you hear me, Advocate Mpofu?
Yes, I can hear you now, Chairperson. Yes. My hand is up.
I hope. Okay, I hope you did hear me when I was speaking and in response to your request. Let me hear you.
Yes, no, I did hear you, Chairperson. But when you said you're going to give me the opportunity, I think like Ms. Bauer, I thought you were going to give it to me now, because I would prefer to do that and get it out of the way so that we then deal with the witness. It's just to place a few things on the record as usual. And then, so I don't want to do that in the middle of the witness's testimony when he has already been sworn in, because then it becomes almost part of his transcript, if you know what I mean.
Well, let's see how it goes. I think you have persuaded the chair to give an opportunity. Let me allow you to do that.
Thank you, Chair. And it won't be long. It won't be long, Chair. Thank you very much, Chairperson. Chairperson, yes, it's about the correspondence that we have received from yourselves yesterday. Yes, unfortunately, we only received this issue the outcome of your deliberations in the media, through the media, which we were quite worried about, because we, as you remember, we had said that we didn't want to discuss the matter in the media before raising it here. But unfortunately, the committee, I think, saw it fit to release a media statement before informing us through this platform here of the developments. But I'm just flagging that as an issue of concern. Maybe going forward, we should just have a protocol of how these things are communicated, because otherwise, both sides can, or all parties and the committee can start with the media before addressing things here, which might lead to undesirable results here. But be that as it may, Chair, we did then receive the correspondence, and that is the issue that we want to address. It was regarding our application to you in terms of 5.3 of the directive to take the necessary steps to summon Mr. Cyril Ramaphosa to appear before the committee as a witness. Now, the two documents we received is your letter, about which I'm not going to say much, because it simply records the discussions in the committee. And we note that the matter was decided probably by majority vote, and we note what is put in your letter about Honorable Heron's position, that the committee should have sought information from us as to why we wish to call the president, or further information, I suppose, more than the information that we furnished. And reading between the lines, we assume that that proposal was defeated by the majority. Okay, so that's all that we have to say about the letter. The issue that we wish to address, Chair, just for your information, because it's connected to the other request you make in your letter about us furnishing you with our list of witnesses by no later than this Friday, so that can be factored into your planning process regarding the program, the proposed program, or the old program, or whichever version of it. And just to assure you that, yes, we have actually made such or reached such an agreement with the evidence leaders in our meeting last Friday. And so we will do our best to comply with that request. But the only connection between that request and what I'm about to address is the fact that it obviously deals with witnesses, with our list of witnesses, and also it might affect how we would have sequenced those witnesses if Mr. Ramaphosa was one of them, or will be one of them, or whatever is going to happen. Right. Now, then the next leg of what I want to then discuss, Chair, not discuss, just place on the record, is that we, as I say, we received the first reports of this from the media, and we almost fell into the trap of, which we shouldn't have, we should know better, of believing the media narrative, which was that there was an opinion against the appearance of the president. But thanks to you, we have now received a copy of the opinion, and our view is that the opinion does not say what is reported in the media, because the opinion at paragraph 46 says that there is no legal impediment that prohibits the committee from summoning the president or any other person to appear before the inquiry. It may do so, and then it explains the criteria Then it says, in the event that the committee is of the view that the president's presence before this committee is necessary, we advise that in the spirit of cooperative governance, the committee itself first invites president before proceeding with the issuing of a summons. And that's really the gist of the opinion. So, and we agree with the opinion, by the way, that there's no legal impediment to the calling of Mr. Ramaphosa. And which means the only legal impediment, quote unquote, is the vote of the committee. In other words, the committee, knowing that it had no legal impediment, voted against calling the person. That obviously then becomes the only legal impediment to his calling. So we want to just record that it doesn't, it's got nothing to do with the opinion. On the contrary, the opinion states the correct legal position. Now, well, at least in that respect, we differ with some of aspects in the opinion. For example, its invocation of the prerogative, some colonial thing called the prerogative, which doesn't exist in a constitutional democracy. But those are just issues that will be addressed in due course. The other issue that we take is that, just for the record, to explain once again, and this would be in support of Honorable Heron's position, that maybe we should have been asked to explain certain things if they were not clear, because we thought they were clear, but obviously they were not. And one of them is the issue of the suspension. When we refer to the suspension in the first letter, we were not referring to the issues that are before the courts. We obviously know better than that. We wouldn't have called the president just to canvass the issues that are before the Western Cape High Court. The suspension does not only concern the issues in the Western Cape High Court, it also involves the overlaps between this process and which would trigger the president's power to suspend, in other words, outside of the issues that are before the court. So obviously that was completely misunderstood, but again, it is what it is here. But apart from those kinds of issues, as I say, we are in agreement with the conclusion of the opinion that there's no legal impediment against calling Mr. Ramaphosa. And I call him Mr. Ramaphosa not out of disrespect, but I'm simply trying to explain another point which we want to place on record. That he, although obviously we had to address him at his workplace, so to speak, we were not calling him in his capacity as the president as such of the country, but as a citizen, as a witness, like any other witness, as a witness who has implicated the public protector in alleged conduct, which would be impeachable before this committee. That's really all. So he is in no different position than a Mr. Van Lochenberg or Mr. Pillay and all those other witnesses who had made allegations in affidavits, and then they were called here to deal with those allegations to support the impeachability or otherwise of the alleged conduct contained in their affidavits. So it's untenable to say Mr. Pillay and Mr. Van Lochenberg, for example, should be called, but Mr. Ramaphosa should not be called. It doesn't make sense. But again, we don't want to debate that issue now because the decision has already been made. So where we are then, Chair, is to simply indicate to this committee that we do not accept the majority decision of the committee to go against the opinion and what we have said. And we would have preferred that if there were issues that need to be clarified, and if there is such an opportunity still, we are asking for it, for us to clarify further areas where there might have been lack of clarity, for example, the suspension issue that I've just mentioned. Failing all that, in other words, if you are not prepared to go that route, then obviously we will then take your letter at face value as the final word on the issue, and then we will take whatever legal steps might be necessary to secure the presence of this necessary witness. The last point, Chair, is to say that which is another fundamental mistake in the approach. The witness is not being called because he may be necessary or deemed necessary by the committee. There are three types of witnesses: those that might be called by the evidence leaders because they find that witness necessary, those that might be called by us, and those that might be called by the committee. So the question as to whether the witness is necessary must be viewed from the point of view of the public protector, who's the person calling this particular witness, who has just refused to come, like any other witness, like Mr. Kakana, who I think had refused to come in respect of the evidence leaders, and they therefore invoke the rules in order to secure his attendance, as he confirmed here. So again, the president in that respect is not any different to Mr. Kakana. So that's another area that seems to be have caused some confusion as to whether the necessity is, in other words, whether the witness must be deemed necessary by the committee or by us who are calling in. Yeah, so that's where we are with that issue, and we are going to, therefore, the only problem, Chair, is that it as I say, it might affect not so much the number of witnesses, because we can always postulate a scenario where he's one of the witnesses and another one where he's not one of the witnesses. I think that's easy to plan. But it will certainly affect our sequencing of the witnesses, because until that matter is resolved, we obviously have a right to sequence our witnesses in a manner that we prefer. So if, for argument's sake, we wanted to call him as our first witness, and I'm not saying that's the case, then it would then affect our, how our next witness would come, because we might not want him to come as number 10 if we wanted him to come at number 1 or number 3 or whatever. I think that it's clear that it will affect at least the sequencing, if not the number of witnesses. So it might cause a glitch in your request for us to indicate in more certain terms on Friday our witnesses, although we will endeavor to do so. Sorry, Chair, let me just check if there's anything else that I'm... Yes, the final point is, yes, there's also some problem with the opinion regarding its invocation of the State Capture Commission case and that kind of thing, because this is not a commission of inquiry. This is a different process. Both of them are not courts of law, but they are completely different. So we don't accept that there's any relevance in respect of the state capture matter. In any event, the part that is quoted doesn't assist the writer of the opinion. But again, as I say, we don't want to quibble much with all those things, because we agree ultimately with their conclusion. Yes,
I think that's it.
That's it, Chair. Yeah, that's it. So long and short is that, yeah, we will advise you as soon as we have worked out our legal position in terms of the legal opinion that we are formulating around these issues. hopefully before the Friday date of the witnesses. But you must just be rest assured that we do not accept the decision, and to the extent that it might be challengeable, it will be challenged, and whatever implications that might have on this body, we will then address it further. Thank you, Chairperson.
Thank you, Advocate Mpofu, for placing all of those matters on the record. Just to briefly indicate as I proceed that the committee would have met yesterday, deliberated on a full agenda of items in front of it, including deliberating on this matter, and it satisfied itself on what was before it, and decided that the matter does not pass the test it's set for itself. In that regard, it's taken that decision as a committee. I would have written, therefore, on behalf of the committee, the correspondence you're referring to. We will await any response that you will formally write back to the committee based on that letter. Just also to indicate that the nature of the work of oversight in all parliamentary committees is the kind of work that is transparent, open to the public. Everything we do and say gets to be reported on the spot. And because our meetings are open to the public and the media. So even before a statement would be issued by the chair on behalf of the committee, media houses of whatever form are in their own right to report. They would even report who said this and so on. So they would have reported a decision of the committee. And so by the time you receive the correspondence formally from the chair, you would have been told, given clips in televisions about what they call breaking news. We have no control over that by the very nature that our work of this National Assembly and Parliament requires us to do, and I think that's well stipulated in our constitution. It's a constitutional obligation. So unless a meeting would have been convened in camera, and when you do that, reasons get to be provided to justify. So I am trying to reflect on your discomfort, which I sympathize with, that before you could read this letter, you already were seeing things flying. And I do know that you understand that fully. You are in this space. The legislature space, you've interfaced with that, and at some point you were in that space. So it's not something that you don't know. I thought I must just explain that. We'll await your response to the letter that we have written to you. I take cognizance of the commitment you make, subject to being able to deliver on the date on Friday. I accept that. There might be some difficulties. I think you have placed those on the record, because that would also have been raised in the letter itself. So I just want to make those points in relation to the issues you have placed on the record, and I think at this point, it is not an item on our agenda. We have noted it. and you have some difficulty even including with the legal opinion. Well, our attitude on the legal opinion, it's very clear that a legal opinion is a decision enabler. It's not a decision on its own. And so we would have taken our own decision as a committee, having read, having satisfied ourselves with a legal opinion, because imagine if a legal opinion says close shop and wouldn't just do that. So it provides a basis for a decision.
No, Chair, you are preaching to the converted. I was saying you are preaching to the converted.
I'm not referring to you.
Okay.
I'm not referring to you. I'm just making the point, but maybe you're right. Let me not labor the point. Thank you very much in that regard. And I think...
sorry
I'm still on the platform.
Okay. I'll take a look. I'll tell you. Sorry.
Oh, yeah. So I just want to summarize the issues in that regard and indicate that to members of the committee, this is not a discussion point, because I would want us to proceed and start our proceedings. You would have raised one or two issues about the witness. I'm going to ask Advocate Bauer to also perhaps clarify that, but I'm now proceeding therefore to the next point, Advocate Mpofu, and I don't want us to have a to and fro and dialogue on this matter. Any quick point you want to raise?
Yes, Chair. Sorry, no. Honestly, I'm not going to have a dialogue, especially if, as you say, there's not going to be any interchange with the members on this point. I've said what I've said. I'm not going to repeat it. Chair, firstly, just for your own comfort here, on the issue of the media, I accept what you're saying. The meeting is open, and it would have been reported, like any other open meeting. The only issue we're raising really was that it was just the discomfort of hearing this for the first time or being asked about it. But that's, I suppose, so are that's what living in a constitutional democracy means. Yeah. So the only concern was to the extent to which I raised that the reporting was distorted. But again, we should not have been surprised by that. And therefore that's why I've placed on record what our reading of the opinion is, and but we're not blaming the committee, but also on our side we will always try to not to raise things in the public space if it can be avoided before we raise them here. That's all I was saying, because for example we were being asked to respond to this yesterday, as you can imagine, Chair. But we refused to do so because we said, no, we'll keep to the protocol of raising the issue here formally, rather than having some media spat about it, so to speak, an unnecessary media spat. So I just want you to understand our position as well, that we will try to do that. But now and again, we might also be forced to place things, to respond, at least when things get into the media before they're placed here.
Perfectly.
Thank you, Chairperson.
That's perfectly in order. Thank you. I am with you. I understand that, Advocate Mpofu. Thank you very much. Can we now proceed and I invite Advocate Bauer? And should I start with Ms. Ibrahim? Okay. Ms. Fatima Ibrahim, can you please lead us and deal with the preliminaries of the witness?
Thank you very much, Chair. Mr. Chair Lala, can you hear me?
Come again?
I'm asking if the witness can hear me, Chair.
Maybe I will ask you to introduce yourself as you're going to do to the witness. Just place on record who you are.
I'm Fatima Ibrahim, a legal advisor to Parliament, and I'm going to be administering your oath. Can you hear me?
Yes, I can hear you. Good morning.
Good morning. Can I please ask that you state your full name for the record?
Gumbi Chialela.
Thank you. Mr. Chialela, you have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Enquiry. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of this inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or imprisonment for a period not exceeding 2 years. I'm now going to require you to take an oath or to affirm that the evidence you are about to give is truthful. Which do you prefer?
I prefer an oath.
May I ask that you please raise your right hand and repeat after me? I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Thank you. Chair, the witness is now duly sworn in.
Thank you, Ms. Fatima Ibrahim. That was well done with the slow pace. And thank you to Mr. Chialela as well. I now hand over to Advocate Bauer.
Chair, before I turn to posing questions to the witness, I need to put the witness's evidence into a context and also alert the committee to Advocate Mpofu's position in respect of the witness. The committee will be aware that charge 4, and I quoted from the motion, is a charge that states as follows: that Advocate Nkubani is guilty of misconduct in that Advocate Nkubani has intimidated, harassed and or victimized staff. Alternatively, has failed to protect staff in the Office of the Public Protector from intimidation, harassment and or victimization by the erstwhile CEO of the Office of the Public Protector, Mr. Vusi Mashlango. In particular, the following staff members who have been threatened with or had disciplinary action taken against them, unlawful and trumped-up charges. Now, this witness is the acting head corporate services in the Office of the Public Protector, who essentially oversees the management or the department or care of human resources within the organization. The committee would, in its deliberations, have to make a call on the question of intimidation, harassment, and or victimization of staff. And what is before this committee in evidence and will be put in evidence or is contained in the motion already is instances of employees who have been dismissed, employees who have been charged, employees who have received Audi letters, letters which we will explain in a bit. And the context is to make a determination that within an organization, whether steps that are taken in relation to employees fall into the category as predicated in the motion or fall into a category as to whether that falls within simple or labor-related or human resource management within the department, or organization. And for that reason, the evidence leaders felt that in respect of people who appear or whose names have arisen in this context, that it was important for the committee to hear what the leadership in relation to human resources could place before the committee in relation to what is contained in documentation that falls under his control. So that's the context of it. Mr. Mpofu reflected to me that he thought the evidence would be irrelevant. And I think he may make that motion to the chair once I stop, and that for purposes of curtailing the duration, he didn't intend to cross-examine the witness, although he reserved his right to ask a few clarificatory questions on issues raised in sections A, B, and C of the affidavit, and sections D, 2, 3, 4, 10, 12, 14, 15, and 16, in an endeavor for us to assist in the process today. Mr. Chirela, good morning.
Good morning, Advocate Bauer.
Currently, the acting head corporate services in the Office of the Public Protector, correct?
That's correct. Chairperson.
And by virtue.
Sorry, Advocate.
Did I hear? Did you, Advocate Mpofu?
Yes, Chair. Sorry, I think you didn't see my hand.
Okay, sorry.
Yes, no, Chair. Yeah, sorry, I'm sorry to both the witness and Advocate Bauer. Yeah, yes. No, as she indicated, I had indicated to her that I was going to say something about this witness before he starts. And again, I won't be long. Firstly, I confirm the sections that we are saying that we won't necessarily deal with. In other words, which we are not disputing, in line with the guidance of Honorable Heron, as indicated by Advocate Bauer, although we have reserved our right to ask a few clarificatory questions should it transpire that is necessary, because sometimes the oral evidence naturally goes further than what is on paper. But the most important thing, Chair, is one in respect of which you may need to make a ruling if you are so disposed here, and that is the issue of relevance that Advocate Bauer raised, or rather said we were going to raise here. We can't work out exactly what this witness is going to add to the issues raised, even in that charge of victimization, harassment, and intimidation, because he doesn't make any such claims. But I mean, maybe I should just read it as we indicated it to Ms. Bauer. We said, in respect of the witness Jalela, we are of the view that his evidence is irrelevant to the motion. However, we know that the chairperson will rule otherwise if previous experience is anything to go by. Therefore, and to curtail the duration, we do not intend to cross-examine on this and that, and as we explained earlier. So that's our position, Chair. I think just as a formality, that's our objection to the witness, and you may rule that he is relevant, and then we go ahead.
Before I go to Advocate Bauer, Advocate Mpofu, I'm sure we'll agree here. I don't want you to bring a briefcase. you know my briefcase story. I don't want to bring a briefcase of rulings into this. I welcome that you are placing on record that you don't believe, and based on what you have, you don't think that there's relevance about the witness on which evidence will be laid. I think I firmly take that, and you want me to roll on that. But before I make the ruling, just to make the point that you can't be knowing what ruling I'm going to make. Even if you have got abilities to read one's mind, or you have the ability based on some form of a track record, I wouldn't want you to make those conclusions.
Okay, sure.
I would have indicated before that we're going to deal with each witness, understand and deal with those issues, because the way you're putting it now, in other games is called a preemptive strike. So that I do the opposite.
No, you can surprise us, Chair, but we're not some homers, but we can do what in mathematics is called extrapolation.
No, thank you, Advocate Mpofu. So I'm just indicating that as much as I'm asking you not to, I also don't have briefcase rulings that for everything on the table I will rule in a particular way. I want you not to go that level about how you understand the chair in doing this. We've been consistent. Perhaps we have made this point before, and we'll go to a ruling that says allow the committee to go through this and listen to the evidence that will be led with the witness, and I'm sure before the end of the day we would or when they deliberate and ask their questions, members would deal with some of those issues. For now, the only ruling I will make that we proceed and share the evidence and interact with the witness. But I did not come with a ready prepared ruling on the matter. Thank you, Advocate.
Thank you, Chairperson. We understand and we are suitably surprised. Thank you, Chairperson.
Thank you, Advocate Mpofu. Let's proceed, Advocate Bauer.
Can I maybe for the record also say that when we look at witnesses, we don't only look at them to make out a case as such as I seem to be understanding it, as to does the witness evidence support intimidation, harassment, and or victimization, but also whether there is evidence which shows something to the contrary. In other words, it seemed logical that if you're talking about harassment of staff, that HR needs to talk to the committee. But I leave it at that. Maybe, Mr. Chialela, can I come back to you? And I apologize that we've delayed your evidence. Your affidavit for the record is to be found in Bundle D at page 3383. Now, by virtue of your position, and I'm going to take you through things very quickly, given Mr. Mpofu's position on the evidence. You have documentation under your control. You've provided us with access to that documentation. And some of the documentation has been annexed to your affidavit or have been provided to the committee and have been used by other witnesses or in that regard. You also indicated to us that you don't necessarily have personal knowledge of every item in the document, but you're before the committee for purposes of assisting the committee. And if there's anything you can't deal with orally, you will indicate such and endeavor to obtain that information and provide it to the committee in writing. Is that correct?
That is correct.
Right. Now, I didn't detail it in your affidavit, but possibly for purposes of the committee, could you just explain what your position entails within the organization? You have an acting position and the position you occupy in a permanent post.
Okay, thank you, Chair. My substantive position is Senior Manager, Human Resources, but I'm currently acting as the Executive Manager, Corporate Services.
Right. And can you just say how long have you been with the PPSA, and in your position as acting head of corporate services, what departments fall under you?
I joined PPSA in April 2016, and the units that fall under me are Human Resources, Facilities Management, Legal Services, Knowledge Management, ICT, and Communications.
Thank you. Now, the first section of your affidavit deals with organograms, and there are approved organograms within the organization that sets out what funded positions are within the PPSA, correct?
That's correct, sir.
And these are usually detailed in your annual reports. As far as organograms is concerned, there's only one issue I'd like to confirm with you, that the position of Chief of Staff has always been a funded post since 2016 at least. Is that correct?
That is correct, sir.
Right. Then if we go to policies, the organization itself has a number of policies which you've provided to us on various issues ranging within the organization, correct?
That is correct.
And you've given us the register reflecting those policies, and a number of them are detailed in your affidavit. And these are updated every few years, is that not so?
Yes, that is correct.
Right. And right. Then, and these policies, to who do they apply?
They apply to all PPSA staff.
Right. That would not include the executive authorities, save to the extent that the policies empower them to do something specific, correct?
That is correct, yes.
Then in section C, you set out two of the documentation dealing with the austerity measures that have been put in place in the organization, which is annexed to your affidavit at 3416 and 3418. And if you could just go to, they're not materially different, correct?
No, they are not materially different. That is correct.
Right. And can you tell us what usually underscores these cost containment measures that are imposed?
Well, it would be circulars, for example, from the National Treasury. It would be our spending throughout the year. We receive quarterly reports from finance. Then that will determine whether we should take action, whether if, for example, we foresee over expenditure at the end of the financial year. So those would require us to make decisions during the course of the year regarding spending.
Right. So in fact, on the first memo, one of the concerns was indeed over expenditure in 2018, 2019, as you see from the memorandum attached. You see that?
Yes, that is correct.
In paragraph 2.1, which is at 3417.
Yes. That is correct.
we see that the nature of austerity measures or cost control. Mr. Jalele? You
are breaking. You are breaking. I did not get that.
Okay, so the question to you is that if we look at paragraph 2.3 and we see the nature of the cost containment measures, then they relate to catering, traveling, accommodation, in this regard, specific to the organization, further outreach clinics beyond what is required for target purposes, the usage of telephone, traveling, etc. Correct?
That is correct.
Right. And in fact, we see similar cost containment measures in the next memorandum, which is issued in September 2019, which is at GT2.
That is correct.
Right. Now, in paragraph 10 of your affidavit, I asked you, you were asked about the existence of a circular issued by the CEO, Mr. Mashlangu, dealing with the PPSA not opposing review applications, and you indicated you were not aware of that circular, but you were aware of a decision that had been taken. Can you elaborate on that?
Yes, sure, that is correct. I was not aware of the circular, but I was aware of the decisions that were taken because, as I indicated earlier, these matters are reported in our management meetings. So I was aware of the decision that was taken in one of the meetings that we should not oppose all matters that is to cap, that is cost.
Right. Then I further document which was then prepared as reflected in paragraph 11 at effectively our request was a list of employee or labor-related disputes that have arisen and the progress and outcome of these matters, and to an extent the cost incurred by these matters. And you then tasked Ms. Manyiki, the Manager Labor Relations, to assist in the compilation of this document, correct?
That is correct, Chair.
And in doing so, this was done in conjunction with the Finance Department and Legal Services. And if I could just put that document on the screen, and it is to be found at bundle D, it's 18.15 and 18.16. If we could just go to 18.15 first. And effectively what this lists is in 3 categories. Maybe we should work from the bottom up. Go to the table right at the bottom. If you go down. Right. If we look at the grievance column, maybe go up a little bit up where we can see the heading, right? These are, this table only relates to employees at head office, correct?
That's correct.
Right. So these would be just, can I maybe phrase it as the run-of-the-mill issues that are dealt with in the ordinary labor-related environment in an organization. Would you agree with that?
Can you repeat that?
That the nature of the grievances would relate to perhaps what one would call ordinary run-of-the-mill labor-related matters that arise in an organization.
Yes, that is correct.
And who would normally attend to these grievances?
According to our grievance procedure, they start at the lowest level, the supervisory level, and then if it's not resolved there, it moves up until it goes to the public protector. So it goes that is up the management levels until it goes to the public protector if it's not resolved at different levels.
Right. And if we look at this and the grievance has been resolved at the first level, then it never goes up the chain. Would that be correct?
No, that is correct, yes.
Right. Okay, so let's go up to the next table. At which stage of these the next table relates to disputes, although the heading says CCMA, we understand it to be disciplinary proceedings and CCMA, correct?
That's correct, yes.
Right. Now, if the grievance isn't resolved with an employee, then it goes to the next level, and what would that be?
Well, it would go up to the public protector. And then if the grievant is still not satisfied, then he or she can declare a dispute.
Okay, so that's, sorry, I'm phrasing this badly. Sorry, Mr. Chilela. When we look at this list of disputes that's concluded in this list, these are people in relation to whom disciplinary proceedings had been instituted before a disciplinary chairperson, alternatively the CCMA. Would that be correct?
That is correct, yes.
Right. And what this column show is effectively the position the person was in, the nature of the dispute, the status of the matter, the legal costs that had been incurred, and the cost to the organization as a consequence of the award that's been made. Correct?
That is correct, yes.
Right. So if we go down, let's use Mr. Samuel as an example, because he's known to the committee in this way. All right. I'd stop on that page. Go a little bit up. Go up. Oh, no, that's going down. Go up. Right, stop. Right. So it would effectively say Mr. Samuel was the provincial representative of Free State. The issue was an unfair dismissal. The commissioner found that the dismissal was substantively unfair and ordered payment to be reinstated retrospectively. The next column then shows the cost to the public protector's office of running the legal matter, and the final column would show what the award was emanating from the disciplinary proceedings, correct?
That's correct.
All right. Then if we see with Mr. Kakana, it will show that the award was in favor of the PPSA and that there's currently a pending review before the Labour Court, so there's no award that's been made to him. And effectively the costs for Mr. Kakana is then either dealt with in the next schedule, or alternatively, it will be dealt with when we deal with the question of legal costs. Correct?
That is correct, yes.
All right. So in where we discuss any of the employees in your affidavit, then a snapshot is on this schedule.
Yes,
correct?
That's correct. Yes, that's correct.
All right. So for purposes of ascertaining where costs lie, and the question of what is legal cost is one of the issues that we must come to next week with the committee. When you pay out an award to an employee which is labor related, then that award and the cost of the litigation comes out of the litigation budget. Would that be correct?
That is correct, yes.
Right. So a component of what is spent on legal fees would come from labor related matters.
Yes, that is correct.
So for purposes of this committee, not all the litigation costs necessarily relate to the review of the reports that emanate from the Public Protector's Office. Would you agree?
Yes, I agree. That is correct.
All right. Now, if we go to the next schedule that is prepared, right? Which you see at 18.16. Right? There are a number of employees, and there's 7 that's listed here. As a matter of principle, if you go down to the bottom column, it shows the periods of the suspension of these employees and the salaries that are paid during the suspension. Correct?
That is correct, yes.
Right. The total, and I did total it, it's 10 million and something. I don't have the figure here, but I'll just double check it during the tier journal. But the principle that I just want to raise with you, that totals at the bottom don't come from the legal costs bills, but they come from the employment component of the organization. Would that be correct? In other words,
yes.
Salaries, it comes out of salaries.
Yes, it's the cost of employment.
Okay. Right. And then if we turn to paragraph 13 of your affidavit. Right. If you deal with matters which would fall under grievances at the first level, like performance bonuses, job grades, leave policies, if you resolve it at level 1, then it wouldn't entail any public protector involvement at that level. Would you agree with that?
Yes, that is correct.
It is when steps are taken further that the public protector may get involved.
Yes,
would you agree with that?
That is correct, yes.
Then, and further, if you go to paragraph 15, it is also so that when the grievances or labor matters are dealt with internally, then there aren't cost implications. It's only when external service providers are engaged that there are costs incurred. Correct?
That is correct, yes.
Now, maybe we have heard about this Audi letter somewhat, and we're probably going to hear a bit more, but can you maybe from a labor perspective explain to the committee what is an Audi letter?
An Audi letter is a letter that is usually sent by the supervisor to his or her subordinate to explain why he or she has not done what he was expected or supposed to do.
Okay. And what then happens? That letter gets issued and the employee then responds, and then?
The employee responds, and then if the response of the employee is satisfactory, then that is the end of the matter. And then if the response according to the supervisor is not satisfactory, then further action may be taken, and an employee, for example, could be issued with a verbal warning, written warning, or whatever sanction. So that's basically what happens after the Audi letter has been received and dealt with.
Right. We then inquired from you as to give us an indication of whether you issued these letters, and to give us an indication as to how many letters of this nature would have been issued within the organization. And if you could perhaps explain to the committee how this operates.
Thank you. As I indicated earlier, it normally comes from a supervisor, the immediate supervisor, asking the employee to explain whatever the supervisor wants it to be explained. And then if the employee explains to the satisfaction of the supervisor, then that's the end of the matter. If the supervisor is not satisfied with the explanation, then further action could be taken.
And so when a supervisor issues an Audi letter, are you necessarily provided with such letter?
Not necessarily. I mean, that is a line management function. They don't necessarily have to involve HR unless that is they want HR to advise that is on the matter. Otherwise, they don't have to involve us.
So in other words, one of the what you could not provide the committee with is an indication of how many of such hourly letters would have been issued to employees within the PPSA over any period of time, correct?
Yes, correct.
Right. You were then asked whether you had been instructed specifically to issue hourly letters by the PP and the context in which that was done. Could you explain that to the committee?
Yes, I some time ago I received a WhatsApp from the PP asking me to draft an hourly letter to one of the senior investigators because she did not attend the meeting which she was supposed to attend with PP. And PP took that as insubordination.
And what did you then do?
Well, because I did not know the details of the matter, so in an out letter, you need to be specific what you want the employee to respond to. So I contacted the line manager, and then I informed her that I've received this WhatsApp from PP, and I don't know what are the issues. Can you explain? Can she explain to me? And then she said, no, as line management, they are dealing with the matter. I don't have to do anything. They are dealing with the matter. So then I informed PP that, I've contacted the line managers. They are dealing with the matter. So then I left it there.
And what then arose after that?
I assume that they dealt with the matter. I never took any further action that is on the matter.
Okay, and you were never asked, so that was the end of the matter?
That was the end of the matter. PP just raised a concern that they were too slow in dealing with the matter.
Okay, so if we turn to a few of the employees whom this committee has been told about, let me just do it. Mr. Nshunzi had already given evidence, and if we could just go to paragraph 20 of your affidavit. Right, I'm just going to run through it quickly. He had been appointed to the position Senior Manager Security Management in 2017, pursuant to a panel shortlisting him. And there were, and when it's a senior post, do you sit on the panel, Mr. Chilela?
Yes, in senior management positions, I do sit in panels.
And what is you explained that you ask the HR related questions, but you don't score with the panel, but you are involved in the shortlisting process.
Yes, I'm the secretary. I'm usually the secretary of the meeting. I ask HR related questions. I also advise on HR related matters to the panel.
Right. And in this matter, there was a representative from the State Security Agency that sat on the panel. Is it common for external persons with expertise of a particular nature to assist the PPSA in the appointment of posts?
Yes, it is common.
In fact, sometimes you get a representative from the Public Service Association or the Public Service Commission who sits on the panel as well, correct?
Public Service Commission, not association.
That's right. That's my apologies. I wasn't sure which one, so I thought I'll put both to you. Right. Now, at some point, Mr. Nshunzi said he was moved from security to intake assessment and customer services in paragraph 23, and I think the date should be 2019, not 2018, correct? There's an error, typo in your affidavit.
That's correct, it should be 2019.
Yeah, and we asked you whether this was pursuant to a recommendation contained in a report that had been provided by Diale Mogashwa.
Mohasho, yes.
Right? Relating to the overhaul of the security department. Are you aware of this at all?
I'm aware of the investigation that was conducted by Diale Mohashwa investigators.
Were you involved in the decision making in relation to Mr. Nashunzi's transfer?
No, I was not involved.
Okay, so when do you become involved in that process?
Well, because it's an HR matter, I would be informed by the CEO that such a decision has been taken, and then I would be requested to make a submission to that effect.
Right. And then the transfer would take place?
Yes.
Were you aware of a process in the organization at the time of transferring people internally for purposes of matching skills to jobs?
No.
Now, we know from GT3, and we've had this before, so I'm just going to run through it, that Mr. Nashunzi was told to come back to work after the investigation had been completed and that his garden leave had been uplifted. Now, in GT4 is a memorandum in relation to this issue of garden leave, in respect to which, no, sorry, it's not there. It's a paragraph, sorry, it's on 68, and it would be page 1501, just for that. You were asked to advise on this issue of garden leave. Can you perhaps just elaborate to the committee in relation to that?
Yes, there were allegations of leakage of information. And then because the information that was allegedly leaked resides in security management unit. So obviously, Mr. Nashunzi, because he is the head of the unit, he was obviously the suspect. And then there was this issue then of that the matter should be investigated, and then that is what should normally when you investigate that is matters to ensure that the implicated employee is not does not interfere with there are no perceptions of interfering with investigation that they would be suspended. So then this issue of garden leave came in, that is from the CEO as the option. Now we from us as HR, that is, we advise that we should not do it because our leave policy does not provide for such leave.
Right. So if you go to page 1503, what you recommended was that a preliminary investigation report was required on which to base the special leave, correct?
Yes.
Right. And then at the subsequent occasion, Mr. Nashunzi was transferred from the complaint.
Okay, I can't hear you now.
And stakeholder management branch to the provincial investigation branch, and this was approved forward. If you go to
you broke. I did not get that. Can you repeat that?
Sorry, I pointed out that during May 2020, Mr. Nashunzi was transferred to the coastal branch and this was approved by the PP as one sees from 3425 on the 28th of May 2020.
That is correct.
All right. And it was a salaried increase post. It was an OSD post, correct?
That is correct, yes.
All right. And Mr. Nashunzi's position, security position, was subsequently advertised.
That is correct, yes.
All right. And you sat on the interview panel for that position.
Yes, I did.
And people who sit on the interview panel have to complete a disclosure form to disclose conflicts, correct?
Yes, that is correct.
And even if a conflict is disclosed, it wouldn't preclude them from, they do not necessarily have to recuse themselves from the position of being on the panel, correct?
That is correct, yes.
So if we just go to, I just want to get this clear. It's at 1, 3, 3, 6. So just go down. Go down. So even though the PP sat on the panel, if we go down for the positions of PREC and Senior Manager Security, now I just want to look at numbers 1 to 8. All right?
Yes. Okay. I'm not sure that's
number 1. Okay. The disclosure form would tell you that you're not personally related to or know any of the candidates on the short or long list. And where you do have a relationship, it's not of the nature that would risk unfair favoritism, and would then disclose which of the candidates you do know, and that knowledge will not affect your judgment in the shortlist of the interview, and that you would not be influenced by any person to favor any candidate. Correct?
That is correct, yes.
And everybody who sits on the panel would fill out such a form.
Yes, that is correct.
All right. All right. The next person we go to on page 30 of your affidavit relates to the appointment of the Deputy Public Protector. And we asked you for a job description, and you informed us that there was written delegations in place for the Deputy Public Protector, correct? And that these would appear from, and these are contained in what was then his HR file under your control, right? And so if we take you to paragraph 32 of your affidavit, but I think let's just go to GT5, which is the documents relating to the powers of the Deputy Public Protector. Right? If we see the first set of delegations in place was those which prevailed from December 2016, where Advocate Nkubani confirmed in paragraph 2.1 and 2.2 the powers and functions delegated to the DPP, which is oversight pertaining to operations of the Administrative Justice and Service Delivery Branch, including provincial activities, and oversight role on matters of quality assurance relating to adherence to approved operational business and government processes in all offices. Correct?
That is correct, yes.
Right. We then see from GT6 that in May 2017, If we go to the background information that's there, it reads that the minimum information security standards MIS handbook requires the head of any state institution to implement the security competence process of the institution's personnel who are responsible for handling classified information. The most senior personnel of the institution who hold strategic positions are expected to obtain top secret security clearance certificates which enable them to handle classified information. All executives and senior managers, including the Deputy Public Protector, have applied for security clearance to comply to MIS requirements. And it was unfortunate that your application for top secret security clearance certificate was not granted. It wasn't granted because he didn't have the requisite number of years as a South African citizen, correct?
That is correct, yes.
All right. The next page then says, in the third line, the denial to issue the top secret security clearance by the SSA suggests that the public protector cannot delegate tasks which involve classified information. As a result, I've decided to delegate tasks that commensurate with the security competence status of the DPP while awaiting the parliamentary processes to unfold. And then if we go down into the document from number 1 onwards, we see that he's tasked to deal with training and to seek partnerships with CETA and to report to the public protector on a quarterly basis. Are you aware of what parliamentary processes are referred to?
No, I'm not aware of that process.
And are you aware of the matter ever coming before Parliament?
Which matter?
Of the functions to be performed by the Deputy Public Protector. Was it ever considered by the Parliamentary Portfolio Committee?
I'm aware that in one of the portfolio committees, the members of the committee raised concern about the DPP delegation being that of training. That I remember one of the members raised a concern that DPP was relegated to a training officer. They raised concern about the delegations that were given to DPP by then.
And then on the next document, which is at GT7, we see an amendment to the delegations in April 2018, in which over and above the training functions, the DPP projects have come for 2 years and more to chair task team meetings which deal with think tank files and critical files, and all draft reports in section 79 is to be submitted to the DPP for quality checking before being submitted to the PP for approval.
Yes, that's correct. Yes.
In paragraph, it then further states in your affidavit at paragraph 38 that there was then a performance, there was an agreement concluded with the PP on performance expectations. Do you have any knowledge whether those performance expectations were met?
No, I'm not aware of any performance assessment that was conducted between PP and DPP.
And are there any contained in his HR file?
No.
And then the agreement that was concluded with the Deputy Public Protector reflects that if there's a non-agreement in paragraph 39 of your affidavit, it says then it would require the services of an external mediator. Are you aware of any such external mediator ever being appointed?
No, I'm not aware.
And then if you see in paragraph 41, or if we go to GT9, would be more direct, The DPP provided what's called an exit report to the Portfolio Committee of Justice and Correctional Services, which was contained in his file. And if you go down to 12 May, well, on the second page, and to take you to the second page, he details this. He details what had occurred. Go down. Starts the paragraph on 12 May. We've gone through that in evidence as to what had happened. And the next paragraph deals with the restoration of further delegations to him. And in the next page, he says, I also, over and above that, go to the next page. He says, I also served on the executive committee, which consists of the public protector, myself, and the chief executive officer. And he's been asked, I've recently been tasked with chairing all performance review appeals in the organization. And in the next paragraph, he says, the delegations have, however, not been adequately implemented in practice, as I've not received any Section 7(9) notices and draft reports. The think tank structure created by the former public protector, Advocate Lawrence Mushwana, was scrapped in 2017, and officials did not make themselves available for the task team meetings, with the result that they stopped being scheduled. And then we go to the next person, which is Mr. Kennedy Kaposa. Who was he in the organization?
He was the chief financial officer.
Right. And what transpired in relation to him, if we go to 42 of your affidavit? Can you just briefly tell the committee?
He was issued with a final return warning for dereliction of duties. And then he referred the matter to the CCMA.
And then what transpired at the CCMA?
Okay, and then his representatives approached, that is the institution that is asking that the matter, if the matter could be settled. Now that issue was reviewed by the institution, and we were of the view that it would be cost effective, that is to settle the matter and let Mr. Kaposa go and agree on a settlement, and then that would be the cost-effective way of settling the matter. So it was okay.
Oh, sorry. Go ahead, Mr. Chilela. My apologies.
Finally, it was agreed that we should settle the matter, and then Mr. Kaposa be given a settlement, and then the matter will be dealt with.
Right. And the essence of the matter was that there wasn't another position available in the organization to shift him from the CFO post, and again, he could not get top security clearance, which was required by senior officials, so he couldn't continue with his responsibilities as CFO, correct?
That is correct, yes.
And so it seemed that in that context, you recommended the stance of settling with Mr. Kaposa and then not appointing another CFO, but appointing an acting individual until such time as for a period of time, in order to not result in a double cost for the organization, correct?
Yes, that is correct.
Were you involved in the charges that was brought against Mr. Kaposa?
No, I was not involved in charges.
Okay. Right. Now, who replaced Mr. Kaposa?
The institution approach, that is the state security to second one of their senior financial officials to PPSA. So somebody from the state security, from the South African, what is it called? Okay, was seconded to PPSA. State security.
Right, and that person was put in an acting position. Is that correct?
That is correct, yes.
And for how long? Do you recall?
For plus minus a year.
Okay. And thereafter was the position advertised?
Yes.
As far as you were aware, was the public protector involved in the separation agreement that was concluded with Mr. Kaposa?
No.
Okay. Right. Now, if we turn to Mr. Vushima Shlangu, who was the CEO, you were involved in the panel for the appointment of the CEO, correct? You sat on it as it was a senior post.
Yes, I did.
What was the decision? You advertised the post for a 5-year contract period to coincide with the PP's end of term, correct?
That is correct, yes.
Right. Now, the position had become vacant because Mr. Themba Lamini had left.
Yes, that is correct.
Right. Did he, and what was the panel's decision at the time of Mr. Mashlangu's interview? You say that he was the best interviewee for the job. He had the requisite qualifications, right?
Yes,
what did the panel decide?
Yes, he was the best candidate, but there was an issue of that he was dismissed in his previous employment. So then they indicated during the interview that the matter was in labor court, and then the panel was concerned about that. So though he was the best candidate, then the panel recommended him, but on condition that the matter in the labor court is decided in his favor, and he also get the top secret security clearance certificate. So those were the two conditions that were set by the panel for his employment.
Right. And then,
thank you. May I interfere? We will pause there for a tea break and back at 11:45. Hopefully by then, you'll be working towards wrapping up. Thank you.
Recording
Tea break.
stopped.
The recording has stopped.
Thank you. Mr. Chilele, we were at paragraph 51 of your We were at paragraph 51 of your affidavit, and it details that what then transpires is that due to circumstances in the organization with the acting CEO becoming ill and the post being vacant, there was a need for the post to be filled. And then the PP instructed that Mr. Mashlangu be offered a short-term contract for 3 months, correct?
That is correct, yes.
And it was short-term specifically because of the two outstanding issues of his labor court matter and his security clearance.
That's correct.
You say that you didn't really know at that stage that the security clearance would be hampered by the labor court proceedings, correct?
Yes, that is correct.
Right. There was then a performance agreement which was concluded, and it was dated from 1 May 2018 to 31 March 2019, which sets out these functions. And I inquired from you, why would you have concluded a performance agreement for a 1-year period when he was only on a 3-month contract? Could you explain that?
Yes, Chair. When the contract was extended after 3 months, then it was then that the performance agreement was concluded. So it had to be backdated then from the 1st of May, because we had to account for the period he started working at the institution.
Right. And you're referring to the short-term contract that was extended as reflected in paragraph 56 of your affidavit, from 1 August 2018 to 31 July 2019, correct?
That is correct, yes.
And you say that this was done in order, he got a year's period even though neither of the requirements or conditions for his employment had as such been met, correct?
Yes, that's correct.
Right. Now, if we just go up to paragraph 54 of your affidavit, before I go past it, there was a staff meeting, at the very first staff meeting, at which the CEO was introduced to the staff. The issue of his dismissal from his previous employment was raised, correct?
That's correct, yes.
And you say that the staff was informed by the PP that the matter was pending at the Labour Court and that the court processes should be allowed to take its course. And that for that
correct.
reason, appointed. Correct?
That is correct, yes.
Right. And you then further detail that he made a disclosure of what was then a criminal case that was pending, and that was not regarded as being an impediment.
That is correct, yes.
Right. Now, you then say you were instructed by the PP to prepare for a further fixed term contract ending 23rd April, paragraph 56, right?
That's correct, yes.
At the time when you were asked to do so, were you aware that the SSA had already indicated that it would not issue a security clearance pending the finalization of the Labour Court proceedings?
I was not aware, Chair. That is why the issue of security clearance, even in that employment contract, was still subject to. It was still one of the requirements that had to be met to confirm employment.
You've only discovered that in consultation with the evidence leaders that letter existed. Is that so?
Yes.
Now, you then recalled a meeting which occurred in the latter part of 2019 when you were called to a meeting at the PP's office. It's dealt with in 58 of your affidavit. Can you tell us about that?
Yes, I was called to PP's office where PP indicated that there were external people that were coming, that were meeting with her and other officials in the institution. So he requested me to attend that meeting and explain the appointment of Mr. Mashangu as the CEO.
And you could identify two people who was at the meeting, Advocate Nyembi and Advocate Kakana SC, and another person you can't recall, correct?
That is correct, yes.
Right. And you provided the information you were asked to provide. What transpired after that?
Well, after explaining to the meeting how Mr. Masha was appointed, then I was excused from the meeting. So I don't know what happened after I've left the meeting.
And then in December, you received a call from the PP.
Yes,
what did she relate?
Yes, I was home in December. I was on leave. I received a call from the PP telling me that she was going to send a letter to me. I must draft a response to that letter. So she did not say what was the letter about. So I received that is a letter then from the PP, which was Mr. Mashangu's resignation. Then I drafted a response to that letter for PP's signature.
Right. So the next employee we detail is Ms. Cleopatra Musana on paragraph 60. And the issue of her labor dispute had been raised in earlier evidence before the committee. She was initially appointed as a spokesperson in 2017 for a 5-year period, correct?
That is correct.
She has subsequently left the organization, giving 24-hour notice. Right.
That is correct.
Right. Now, could you tell us what occurred there were two essential labor disputes that arose. Advise us as to what was the first issue and how you got involved in this.
Okay, the first issue, I was phoned by the PP's office one Monday morning, and then I was asked to go to the PP's boardroom. When I got there, there was the then chief of staff and also Ms. Musana in the boardroom. And then PP joined the meeting, that is a few minutes later. And then PP was upset. She said she could no longer work with Cleo because she's tired of doing Cleo's work and Cleo is disrespecting her. So she can no longer work with her, and Cleo must go and serve notice at home. And then at that point I intervened. That is, I asked PP that Cleo be excused from the meeting. And then Cleo was excused from the meeting, and then I said to PP that she has just dismissed Cleo without following a process. She cannot do that. And then there was an argument, a short argument about that final, but ultimately we asked PP that we are aware that he no longer wants to work with Cleo, and she must leave this matter with us. We will deal with it as HR, that is, and legal services and the chief of staff. So that was the end of the meeting.
Did you know what was the reason why PP no longer wanted to work with her? What had she done that had caused that?
Well, I assume that it has to do with Cleo's work, because PP said she is tired of doing Cleo's work. So she was not specific what actually happened.
Right. And what was the nature of the disrespect that was indicated to you?
Well, the example PP made in the meeting was that Cleo called her by her first name.
Right. Ms. Musana then went home, and you then had a meeting with the acting chief of staff, the head of legal services, and you indicated to Ms. Musana that the PP no longer wanted to work with her, and that you would then consider alternative options within the organization, correct?
That's correct, yes.
Right. You then say that the acting CEO, Ms. Mutsitsi, was not prepared to sign off on her contract because it was quite a huge amount of money that would have to be paid out, correct?
Yes, that is correct. That was one of the options we were looking at.
Right. You then convened, you and the acting CEO convened a meeting with Ms. Musana. Can you tell me what transpired at that meeting?
Okay, the purpose of the meeting was to consult Ms. Musana on her transfer from the position of spokesperson to communication and stakeholder management branch. So we were in the acting CEO's office. It was myself, the acting CEO, and Ms. Musana. When we were about to start the meeting, then the acting CEO, Ms. Mutsitsi, received a call from PP, and then she left the meeting for about 30 to 45 minutes. And then when she came back, that she just issued a letter that we were prepared, which we're going to issue to Ms. Musana after discussions and consultation. Then he just issued the letter and said that I've done my part, here's the letter. Then that was the end of the meeting.
And Ms. Musana was then redeployed to the position Senior Manager Communications and Stakeholders Engagement, correct?
That letter was transferring her to that position. The purpose of that meeting was to consult with her on that transfer.
Right. So, but Ms. Musana didn't want to be transferred.
No, he didn't want to.
She wanted to remain in the job she was, and she wanted to know precisely why she was being moved, correct?
Yes, that's correct.
Right. She then declared an unfair labor dispute. She took you to the CCMA. She was then awarded 6 months remuneration, right?
That's correct, yes.
And you recommended that it be paid because it was clearly a demotion, albeit at the same salary level, correct?
Yes, that is correct.
Right. There was then a second labor dispute that arose after this was settled. She came back to work and she then left and she lodged a dispute of constructive dismissal. Correct?
Yes, she came back to work, then she resigned, and then after that she declared a dispute on constructive dismissal.
She won the matter at the CCMA and she was given a further 6 months salary on the basis of legal advice and views within the organization. The matter's then been taken on review to the Labour Court.
That is correct.
Right. And it's still pending, isn't that so, Mr. Chilela?
Yes, it's still pending.
And, okay, now we come to Mr. Ndau. Mr. Ndau resigned on 1 November from the position of Executive Manager, correct?
That is correct, yes.
And the PP was informed of his resignation on 5 November and accepted it, correct?
That's correct.
Right. And so effectively his last working day would have, it's a 30-day notice period, so his last working day would have been 30 November.
That's correct.
Correct? Right.
Yes.
At the time when he resigned, was there any disciplinary charges that had been brought against him?
We were busy drafting charges. He had not been, that has not been brought to his attention.
So had there been charges finalized at that stage? No.
Not yet.
So what had transpired was there was allegations made against him. And I'm going to just take you through the chronology quite quickly. There were allegations made against him, and pending an investigation, he was suspended in April 2017, correct?
That's correct.
Right. He resigned from the organization, I think, let me just work out, some 19 months later, correct?
That's correct, yes.
Right. There was an external law firm that was engaged to investigate the charges, and they recommended that he not be charged.
That's correct. Yes, it exonerated him. Yes.
Right. And the CEO then informed him accordingly. Correct?
That's correct.
Right. You have a grievance policy in the organization, and the complainant then, according to that grievance policy, appealed to the public protector in August 2017. Correct?
That is correct, yes.
Right. So now we're now 4 months into the process, and there's and what does the grievance policy say? It says that the PP or delegated authority has 10 days to consider and conclude the grievance and communicate the decision. Did that occur?
It did not happen within 10 days as required by the grievance procedure.
Right. Then in October, which was 3 months later, the PP sought the assistance of the Commission of Gender Equality, and they did what is called a perusal or an analysis of the investigative report and an appeal memo. While they were charged to do an analysis of the investigation report and the appeal memo and call witnesses. Correct?
That's correct, yes.
Right. What did they do? If you look at 91.8, they only looked at the investigation report and the appeal memo, correct?
That's correct.
And they in a letter informed that there was a prima facie case to be answered and recommended that clause 4.4(2) of the grievance policy be followed to finalize the matter.
That is correct.
Right. And if the complainant was not satisfied, she would then need to take to an external dispute resolution mechanism under the Labour Relations Act.
That is correct.
All right. Then you informed Mr. Ndau that the matter had been referred to the CGE.
Yes.
Can you recall when you did that, Mr. Chilela? Let me ask the question differently. Mr. Chilela, have you been able to find the letter that you've sent?
No, I've not been able to find the letter.
Okay. So to the best of your recollection, can you remember more or less when you would have sent the letter?
I think it was around October 2017. I'm subject to correction. I can't exactly remember.
Okay. All right. In January 2018, 9 months later, there's a decision that a formal disciplinary hearing be instituted with an internal chairperson. Correct?
That's correct.
And this was relayed to the complainant a few days later, who was unhappy with the appointment of the internal chairperson.
Yes.
Correct? What was your view at that stage?
When we got the response from the outcome of the CGE investigation, when they said the accused employee had a case to answer, and then PP in the submission indicated that then that is the process, the disciplinary process must be instituted, indicating that it must be done internally. That is, the chairperson and the prosecutor must be internal. And then the complainant was informed about that decision. She was not happy because she was saying that the accused employee was was an executive. So she's not comfortable with that. She thought that it would not be fair that this be done internally. So she then appealed, that is, to PP that this must be dealt with externally, not internally.
Okay.
And then okay.
I'll go on. Continue, Mr. Chair.
From us as HR, that is, we took it as she was not in agreement of PP's decision. So our view was that she was requesting PP to change or to review her decision. And then we advised that, well, if he is not happy with PP's decision, then the matter has been exhausted internally. Then she can utilize external, that is a recourse.
Okay. It was then in March of 2018 that the PP reiterated that a formal disciplinary proceedings should be instituted, correct?
That's correct.
Right. Did you inform Mr. Ndau at that stage about it?
No, I don't remember doing that.
Right. And then 5 months later, the PP appointed a member of the Public Service Commission as an employer representative to finalize the charge sheet and present evidence, correct?
That's correct.
And then by 14th November, that Public Service Commission representative indicated the charges was not yet finalized.
That's correct.
Correct? Right. And it was then indicated that these charges would be ready by 23 November and that the hearing should be convened effectively a few days before his resignation would be finished. His notice period would be completed. And that, in fact, what then transpired was that the charges were completed earlier. They were served on Mr. Ndau on 16th of November. Correct?
That is correct, yes.
But the disciplinary proceedings didn't occur because Mr. Ndau was on sick leave at the time. It was postponed sine die and never came to fruition. Correct?
That's correct, because he had left the organization.
Do you have any documentation or knowledge or any documentation under your control that reflect Mr. Ndau had been informed prior to his resignation that his charges would be preferred against him?
No.
Now, the committee had evidence from Mr. Kakana, and his matter is still pending before the Labour Court, right? But there's two issues I want to clear up with you. When the PP travels, whether she does that with the CEO or without the CEO, is the staff informed of those travels?
Yes, the communications unit does send, that is a communication to all staff saying that PP and these people will be attending this event on this date and this place, as that happens.
So that information is not confidential?
No.
Right. If I take you to paragraph 37 of the affidavit of Mr. Kakana, he mentions you in that affidavit. He was moved at the end of November from the, you had a meeting, he says that at the end of November 2017, you had a meeting with him, is that correct?
That's correct, yes.
Right, and he was informed that Advocate Mkhubane no longer wanted him to work in the private office. Did you tell him that?
Yes.
He then says, when I asked for reasons for this decision, I was told that it was because Advocate Mkhubane was of the opinion that I say too much to the lawyers representing the public protector in the review proceedings. Did you indicate such to him?
Yes, that is what PP said to me when she told me that he should be moved from the private office.
Okay. Let me then take you to the next person, which is Ms. Pasani Baloy. I'm just going to go through it briefly before I get a time nudge from the chair. Ms. Pasani Baloy, was there any complaints? I'm going to paragraph 98 of your affidavit. Was there any complaints ever raised with you about her employment?
No.
To who did she answer?
Functionally to PP and administratively to CEO.
Okay. Were you provided with any performance assessments in an HR file?
No,
Are you aware of any having been conducted before a service has been terminated?
no, I'm not aware.
You say, how did you find out that, well, you say in 99 that Mr. Mashlango called you and informed you that he would not confirm Ms. Poloy's appointment?
That's correct.
What, can you relay the conversation you had with him?
Yes, I was, when he informed him about that, I was surprised because I was made to believe that Ms. Poloy was a good employee, and I was made aware that UPP commended her in her meeting several times. So it took me by surprise that is Mr. Mashlango was not confirming her appointment. The other thing which I raised with Mr. Mashlango was that Ms. Poloy, as far as investigation is concerned, is not reporting to Mr. Mashlango. So I did not understand how could Mr. Mashlango make such a decision, because he was not reporting to him or that is on her work, especially investigations.
You indicated that he was...
So I raised those concerns with Mr. Mashlango when he informed me about not confirming her appointment.
Okay. You indicated in your affidavit that her being a good employee was not the only determination, but there were other things. Can you elaborate on, did Mr. Mashlango elaborate on what those other things were?
No, it did not say, because I asked, as I said, I could not understand why her employment was terminated, because I believed that she was a good employee. And then he said, no, there are other, they are not only looking at that, there are other issues, there are other things. Then I asked what other things, then he did not tell me what other things that is has he looked into.
Now, in respect of Advocate Matlawi, were the charges against him the same as the charges that were brought against Mr. Kakana?
No, they were different.
Can you just tell us what they were?
Well, there was, Mr. Matlawi attended a meeting in Bloemfontein, which was addressed by the CEO with our provincial office in Bloemfontein, with staff in Bloemfontein. And then he raised issues in that meeting which were not correct, and then that is where the charges of Mr. Matlawi emanated from.
What do you mean he raised issues that wasn't correct? Who raised issues? Mr. Matlawi or the CEO?
Mr. Matlawi in the meeting, is in CEO's meeting with staff.
Right. So who raised issues that were incorrect?
It was Mr. Matlawi.
Mr. Matlawi raised the issues. No, wait. Sorry, Mr. Chilela. Let me just take you back. There was a meeting that the CEO addressed the employees at the Bloemfontein office, and he relayed certain information to them. Correct?
Yes.
And what did Mr. Matlawi then do that resulted in being charged?
The issues Mr. Matlawi raised in the meeting were related, for example, to the appointment. I think it was related to the special advisor, and then the organogram that was not consulted in the bargaining forum.
Okay. You were not involved with this directly, were you?
No, I was not. I was not in the meeting.
Now, was Mr. Mashlango informed of the resignation of Advocate Matlawi?
Yes, he was informed.
And how was he informed thereof?
Okay, when a staff member resigns or leaves the organization, a submission is made to the CEO or the PP, depending on the level of the employee. So in this case, the submission was made to Mr. Mashlango, informing Mr. Mashlango that Mr. Matlawi had tendered his resignation.
Right, and that resignation is at GT 14 of your affidavit.
Yes.
at 3460. Correct? So on the 30th of November, you sent Mr. Mashlangu a notification that he had resigned. Correct?
That's correct.
And if you look at 3463, if you go down, there's something written there. Can you read it, Mr. Chilela?
Yeah, I'll try. Shall please note that I once requested meeting with Matlawe, and on the 26th November 2018, and I was told he was in court. He was at court. Can I please have proof of leave form?
All right. Now, Mr. Who wrote that, Mr. Chilere? Whose handwriting is that?
It's Mr. Mashlangu's writing.
The disciplinary proceedings against Mr. Matlawi was commenced and set down on the 21st of December, correct?
That's correct.
On whose instructions was that done?
Mr. Mashlangu.
If we go to the next three persons, Ms. Mokhaladi, Ms. Sikela, and Mr. Madiba, it was Mr. Mashlangu's decision to institute disciplinary proceedings against him in October 2019, correct?
That's correct, yes.
And they were asked to make representations on the intended disciplinary action.
That's correct.
Did they do so?
Yes, they did.
And there was no mention of a suspension in the letter, correct?
That's correct, yes.
There was then a toing and froing. They were then charged, and eventually the disciplinary proceedings took place subsequently, and in fact it was split between Ms. Mokhaladi and Ms. Sikela on the one hand and Mr. Madiba on the other, correct?
That's correct, yes.
Right. Now the PPSA led the evidence of two witnesses, Ms. Karina van Eerden. Who's that, Mr. Chilele?
She's one of our senior investigators.
Right. Now, she reported to Ms. Mokhaladi, correct?
That's correct, yes.
It was suggested by the CEO in evidence. I recall asking him the question as to why was disciplinary proceedings not taken against Ms. van Eerden in the matter, and he indicated that her line management should have done that. Now, if disciplinary proceedings was being taken against the line managers, could they in turn be taking disciplinary proceedings against persons who reported to them?
Yeah, that would be difficult.
They were then found guilty of charges, and the chairperson made a recommendation of a sanction of a suspension and without pay for a period of 3 months, coupled with a final warning for Ms. Mokhaladi and for Ms. Sikela 2 months with a written warning. You say that the PP was not in agreement with the outcome of the disciplinary process. Could you explain that?
Yes, the PP felt that considering that is the seriousness of the charges and the ruling of the disciplinary of the chairperson of the disciplinary hearing, that is, she felt that the sanction was not appropriate.
And what did she want to do?
Well, we discussed it, and then they were given, that is, they were asked to make representations as to why they should not be dismissed.
And there was then urgent application. They were brought back to work, and there was a review pending on the part of the PPSA at the Labour Court, correct?
Correct, that's correct.
Of the disciplinary chairperson's decision.
Yes.
Now, if we turn to Mr. Nyembi, he was initially appointed as a special advisor for a period of 3 months on a fixed term contract.
That's correct.
So the special advisor is appointed at the behest of the public protector, correct?
I'm not sure what you mean by that.
There's no advertising for a special advisor and a panel and an
Yes.
appointment.
Yes, that is correct.
All right. Okay. And what happened when the 3 months period ended?
Then her contract came to an end.
Okay.
He-
And Mr. Nyembi left the public protector's office after the 3 months.
That's correct, yes.
Right. There was then an issue raised, I think it emerged, if I remember correctly, in the media about the acting chief of staff not having the appropriate qualifications. Do you recall that, Mr. Chirera?
Yes, I do recall that.
Was it correct?
What was correct?
Did she have the qualifications for the position of acting chief of staff?
No, she did not have.
She was then, she had been moved from customer services to be acting chief of staff. And how long was she in that position?
For plus minus a year, I can't remember the exact period.
This was one of the issues that had been raised by Advocate Matlawi, correct?
That's correct, yes.
Now, the post of chief of staff was then advertised.
That's correct.
Right. Mr. Nyembi then applied, he was interviewed, and he got the job, correct?
That's correct, yes.
Now, if we come to Mr. Samuel, this issue related inter alia initially to an assault that took place in 2011, correct?
That's
Inter alia,
correct.
but let's deal with the assault first. Right? And when did this come to your attention for the first time?
Towards the end of 2017, when you received a claim from the complainant who claimed an amount of 350,000 because he was assaulted by a PPSA official.
And there was no mention of this in his HR file, correct?
No, there wasn't, yes.
Right. And you were not employed in 2011, so you didn't have any knowledge of that.
No, I did not have any knowledge.
So I want to put the proposition to you, Mr. Chilele. If in 2011 the matter had been investigated by the CEO at all, if they had gone off and they did an investigation in Limpopo and they found that Mr. Samuel had indeed been intact and he was only defending himself, would there have been any basis for him to be charged in 2017 at all?
No.
Now, what informed you didn't? You're not aware whether the CEO had made any contact with Mr. Mtetwa, who was then the CEO at the PPSA when this occurred?
No, I'm not aware of any contact that she made.
Right. And you sent Ms. Manyeki to go and talk to the employees at Limpopo, but there were no witnesses that could exonerate him or implicate him, correct? They had all only arrived on the scene after the altercation had already started.
That's correct.
Right. Now, you then say what had informed the decision was that he had paid an admission of guilt fine, correct?
That's correct, yes.
Right. And had he at the time told you that he did that to avoid imprisonment, and that he was appealing both the conviction and the sentence.
Yes, he did inform me about that.
And the decision to institute disciplinary action, was that taken by the CEO, Mr. Mashlangu?
Yes.
Mr. Chilele, you were not able to tell me when I spoke to you as to when that decision was taken. Have you been able to find anything subsequent thereto that could tell us?
Yes, I did find a submission that went to PP. That is all that on the matter from HR, that is the legal services, that is on the matter, where we were suggesting, we're commenting that.
Do me a favor. This was when I poured out because it was overfull. Why don't you just heat that one for me and then I'll drink it?
Sorry, Mr.
Okay, can I continue?
Continue. I think there was an interruption.
Okay, there was a submission that went to PP in February 2018, where we were advising that we should wait for the court process to be finalized. We should wait for the appeal. We should not charge Mr. Samuel. We should wait for the appeal. And then PP did not agree, that is with that. She said that is the disciplinary process should proceed.
Mr. Chalela, I don't have that. In fact, you didn't have that yesterday when I spoke to you, correct?
Yes.
Before I'm accused of it. Could we arrange for you to forward that to Mr. To Tembankosi Ngoma, so that we can have a look at it to do that. I'm going to leave that off. Do you then know what happened after February 2018?
Yes, there were a number of legal advices that were sought. The first one was the internal, and then the second one was from a firm of attorneys, external, and then the third one also was external from the senior counsel.
And what was the upshot of all of that?
The first one from internal and the second one from the attorneys were saying we should not proceed with the disciplinary process because the matter is old, and we did not have justifiable reasons why it took so long, that is to deal with. And then the third one from the senior counsel was saying we can proceed with the matter, but we must have reasons why it took so long. That is for us to take disciplinary action.
And what was your concerns?
My concern was that, I mean, this happened in 2011. This was 2018. So the delay was unreasonable, and we did not have, we did not have justified reasons, that is to explain to whoever can ask why was the delay. So that was the concern. But at the same time, we're also concerned about the nature of the alleged, that is a transgression. It was a serious matter. So there were those two issues, that it was a very old matter, but we felt that we should not proceed. But at the same time, that it was a serious transgression, which we felt that it could not be left unattended.
Do you know how it came about that he only gets charged on this in February 2020? Or was it March? Sorry, I must get the exact date. But he only gets charged. His evidence before the committee was that he was only charged after he had made a submission or provided an affidavit to the Parliament, and that had come out in the media. And then he was charged on those charges and the assault charge together with that.
Yes, as I said, there was a lot of discussion when we became aware of the matter. There were several legal advices that were sought. The initial charge of Mr. Samuel was only on this, that is Limpopo matter. And then, but before that charge was issued, then these other things happened, and then they were added to that charge.
Okay. Right. There's this question of annual leave, which is dealt with in 120. And you say that annual leave effectively in 2021 was cancelled until the backlog project had that correct?
That's correct.
And that meant, or there's currently a process underway to pay people out for the leave that they were not permitted to take.
That's correct.
You know that there's a panel of attorneys that has been appointed. Are you involved in that process at all?
No, I'm not involved.
Okay. You have since 2021 again embarked on a wellness project to assist employees with challenges, correct?
That's correct, yes.
Okay. Thank you, Mr. Chair. Those are my questions.
Thank you, Ilan. Thank you, Advocate Bauer. It's now just 34 minutes before 1. We're going to take this opportunity and invite Advocate Mpofu and hand over to him for the beginning of cross-examination. Advocate Mpofu, I recognize you.
Thank you, Chairperson. Chair, can I make a request? I'm going to try to do this as quickly as possible, but I'll probably give you an indication at about 1 o'clock. If I think that I can finish as quickly as I think I might, can I then ask that we go on, we just go straight through to about 1:30, so that when we break, we don't have to come back unless if there's another witness. Or I suppose there might be questions from the members. But can we, all right, I'll indicate at 1 o'clock, Chair, either way. Yeah, thank you.
That's in order, okay. Let's see.
Thank you. Thank you, Chair. Good afternoon, Mr. Chalela.
Good afternoon, Advocate Mpofu.
Kunjani mhlezi?
Sikhona khona unjani wena?
Hayi siyavuka nathi. All right, I'm going to try and give you where I can leading questions, and I hope you'll just give me that's correct or that's not correct and all that, just as you've been doing with Advocate Bauer. That's what gave me the optimism that we might move fast, but sometimes these things change. Okay, so can we try that?
Yes.
Okay, thank you, Mr. Chilela. Chairperson, can I, before I address the witness, can I just raise just 2 unrelated issues very quickly with you?
Go ahead, Advocate Mpofu.
Thank you, Chair. No, I just forgot in the morning when I was talking about housekeeping or issues not related to this witness. One was just to place on record, I think you indicated this in your introduction, but without elaborating. Place on record that we, myself and Advocate Shabalala are in, are in Johannesburg and linking via Zoom. But the public protector and Advocate Maklape are attending personally in your committee over there in Cape Town. And just to explain, the reason for that, Chair, is related to the discussion you and I were was having this morning, we are trying as much as possible to tackle the issue of collecting evidence from witnesses. So we decided to split the team. So we have half of the team dealing with witnesses who are based here in Gauteng, and the other part of the team dealing with witnesses who are presently in Cape Town. So that's the only reason. Otherwise, we're able to manage the situation by WhatsApp or consulting during the breaks. I just wanted to place that on the record, Chair.
Thank you. I thought you were in Rustenburg, so you in Johannesburg now.
Don't go there, Chairperson. Unless if you want me to start. You want me? I'll start a song just now. All right. No, thank you, Chair. Yes, the other one is probably on a lighter note, like the one you've just raised. Well, in the morning when we were talking about the advice from the legal advisors of Parliament, I said that you were preaching to the converted. So I didn't explain that comment, Chair. I just wanted to say that I accept, as you probably know, that when there's a body that is advising, the one that is making the decision is not bound by it. So I accept that your committee was not bound by the advisor's advice. And I'll leave it there. I think you know where that one is going as well.
As the committee was not bound by the panel report.
Well, except that then it means the panel report was, no, the panel report was not advisory. It was a very serious matter that had judges.
Go ahead, let me not disturb you. Please proceed, go ahead.
Otherwise, it was a waste of money. But that one will resolve in another forum. Okay, thank you. Mr. Chalela, back to you. You had the discussion I had with the chair at the beginning about the relevance of your evidence. Our view is really that we are completely at sea as to why you have been called. But since you are here, I'm going to ask you a few questions just for your assistance. Do you accept that?
Yes, that's fine.
Thank you. Yeah, because you see, we don't want, this committee is now at the risk of turning itself into the HR department of the PPSA or some CCMA agency or the labor court here. But I don't think that's the intention. So you accept that there are the policies that you have listed there would be ordinary run-of-the-mill policies in an institution such as PPSA, correct?
That's correct, yes.
And if I understand your evidence correctly, really, you've just given us this morning, what normally happens in an organization of this size. There'll always be some HR issues, some might be resolved internally, others might go to the CCMA, others might go to the labor court. That's the nature of the business, isn't it?
That's correct, yes.
Yeah. Okay. And incidentally, how many employees in total does PPSA employ, roughly?
Plus minus 350.
Good. So it's quite we would call it a middle-sized to large employer, correct?
Yes.
All right. Okay. Now, or rather, in the policies that you have put at paragraph 5, I think you just forgot one, or at least one that we are aware of. There might have been another one. So if you agree, we'll just ask if the members can insert it as 5.19, and that would be the security policy. Correct?
That's correct, yes.
Yes. And the only reason I'm raising that is because it's one of the policies that has been raised in this committee in a different context. That's the one that contains the requirements for security clearances, correct?
Correct.
And vetting and that kind of thing. Correct?
Correct, yes.
Yes. Okay. And now, there's just one thing that I would like you to assist us with, because it's been a bit fuzzy and not properly explained. Are you familiar with the PFMA by any chance?
Yes.
Okay. If you can't, again, I'm just taking advantage of you. So if you are not here as an expert on the PFMA, but so if you can't assist, just say so. But would you agree that although the public protector is referred to as the executive authority, correctly so, but strictly speaking, if you look at the PFMA, because the public protector is a unique entity, that in actual fact, the role almost straddles between the executive authority, but also as accounting authority. You would know, for example, in an entity, an SOE, the accounting authority would be a board in terms of the CC, the PFMA, correct?
That's correct, yes.
Yes. So would you agree with my categorization that there is a little bit, there's always an overlap, for example, between the CEO, the chair, and the minister and all that. But would you agree with my characterization that although strictly speaking, she is the executive authority, but she also carries out some of the functions that would ordinarily be carried out by the accounting authority, namely a board, for example?
Accounting authority, not the accounting officer, the CEO.
No, certainly not the accountant. Yes, no. Just to be clear, yeah, there's the accounting officer, that's the CEO, that's clear. And then in a normal PFMA company, then there's the accounting authority, that's the board. Yes. Then there's the executive authority, usually the minister. Yes. I'm simply saying in this example, the PP's role can be likened to that of the minister insofar as she's the executive authority. But because there's no board at PPSA, the CEO basically also reports to her as if she was the board. Agreed?
That's correct, yes.
Okay, thank you. We'll canvass that when we deal with the PP herself. But okay, thank you very much. I just wanted to clarify that. Then the relationship then between you as part of management and the PP is also that there are certain things, I think you've explained this, there are certain things which might end with the CEO, but there are others which you might want to escalate to the PP, which you would do so if there was a board, correct? In a normal company. Yeah,
that's correct, yes. That's correct, yes.
Thank you very much. And maybe let's just get rid of what I regard as the only issue on which your evidence might be of any marginal relevance. You have confirmed that when we talk about legal fees, that includes both the issues to do with the reviews, as well as what my learned friend Ms. Bauer called the labor-related legal issues, correct?
That's correct, yes.
Yes. And then, are you familiar with are you a numbers man, or are you one of these people who don't like reading numbers?
I don't like reading numbers.
Okay, fine. Then I won't overburden you with the annual financial statements. But generally, then, are you aware, and you may or may not be, that as far as the annual report is concerned, under the item called consulting fees, in that is embedded legal fees as well?
That's correct, yes.
Yes, and the legal fees. Oops. Oh, so I'm sorry, Chairperson. sorry, Chair. Somebody just fallen off a chair.
Somebody disturbing you there?
No, someone just fell off the chair, literally. But I don't have to use my pen, fortunately.
No, okay, we could not see it, but we could see that it's disturbing.
Yes, yeah, thank you very much. Yeah. No, thank you, Chair. I was saying, Mr. Jalela, that that item also includes the consulting fees item in the AFS, also includes other consultants that might be of whatever nature that might be hired at PPSA, correct? In other words, it doesn't only include the external consultants that are legal in nature. To your knowledge, if you don't know, you don't know.
Can you repeat that? You broke.
Okay. You and I have agreed that the item called consulting fees in the annual financial statements includes both what Ms. Bauer would call the review-related legal costs, but also the labor law-related costs. Right. Yeah. Now, I'm saying it goes further than that. It also includes consulting fees, which are not even legal in nature, that item in the annual financial statements. If you know.
I'm not sure.
You're not sure. Okay. That's fine. Let's leave that. But, okay, I can then make the point more narrowly than I intended to, which is this. Because Mr. Samuel wanted us to believe
Advocate Mpofu.
Yes,
just want to trying to follow you.
Yeah.
Is Mr. Jela saying it's not sure if it includes legal fees, because he would have responded earlier and said yes to legal fees.
No, Chair, sorry, I'm sure the confusion is caused by the disturbance that happened there. No, my understanding, and Mr. Jelela will confirm, is that he agrees that the item consulting fees includes legal fees.
Okay.
He also agrees that that item of legal fees can be split into two, namely review-related legal fees and labor law-related legal fees, and I suppose any other legal fees. That's fine. Yes. So the only. Thanks. Thank you. So the only issue Mr. Kelela was not able to assist us with are the other items which are not legal at all, which are embedded, other consultancy fees which are embedded in that item. Am I right, Mr. Kelela? Is my summary correct? Mr. Kelela?
That is correct, yes.
Thank you. Thank you very much. Thank you, Chair.
Thank you, Advocate Mpofu. I follow you now. Thank you.
Thank you. All right. Now, I was then saying, I'm going to ask you then that question more narrowly than I intended. And it is this, because Mr. Samuel gave the impression to the committee that any movement in that item of consulting fees only has to do with what he calls so-called reckless litigation related to the review matters. Surely then, even if you are not a numbers man, you know that that must be incorrect, because the movement in that item may be influenced, for example, by movement upwards or downwards in the labor law related legal costs. Agreed?
That's correct. It could be any of those that are in that budget item.
Yes, or any other item, which I know you cannot confirm, any other item that might be embedded in the rubric of consulting fees, correct?
If those items are part of that, as I say, I can't confirm that.
Sure. But if they are, then movement in them would also influence the total, correct?
That's correct, yes.
Thank you very much. Okay, that's fine. All right. Then we then came to the issue of Audi letters. You can assist us there as well. Again, this has been, for lack of a better word, weaponized, in my view, in a negative way. But I see this as a good thing. As an HR person, would you agree that it is good practice to give somebody an opportunity to explain any possible allegations that might be leveled against them?
That's correct, yes.
Yes. And in fact, as the name implies, Audi means hear the other side. It's an opportunity for the employee to be heard, correct?
That's correct, yes.
And as you said, if the explanation is adequate, that's usually the end of the matter.
That's correct.
And it would be ludicrous, to put it mildly, if you had the statistics at your level of every time some line manager gives their subordinates an Audi letter, because that happens all the time. I mean, these are conversations that take place across the whole country at any given time, correct?
Yes, that is a line management function.
Yes. So if I'm sitting in the Mpumalanga office, and one of the people who are working with me doesn't perform or doesn't come to work or comes to work drunk or whatever, I might give them an Audi letter. I don't have to then report that to head office, correct?
No, that's correct, yes.
Yes. The only time it will come to head office is if, let's say, they don't give an adequate explanation and maybe it's serious enough, and then they now have to be charged, correct?
That's correct, yes.
Thank you. Now, and in fact, in respect of one of the witnesses, we likened this to a warning letter, but it's actually not even a warning letter. It's prior to a warning letter, correct?
Yes, correct, it's prior.
Yes. It's merely an opportunity to respond, which may or may not be followed by a warning letter, depending on the content of the response, correct?
That's correct, yes.
Yeah. And I would say that, yeah, well, I think it's a commendable practice. Some employers may not have that kind of practice. So you'd agree then the process in a nutshell is that, let's now say your response to the Audi letter is not adequate. So you'd have the Audi letter as step one, correct?
Correct.
And then you then have the first verbal warning, correct?
Correct.
And then you'd have a written warning, maybe, depending on the nature of the offense, correct?
Correct.
And then the matter would be escalated to, or rather, a decision to charge you would be made, and then it would be sent, or rather, which one happens first? Is it first sent to the external investigators, or is the decision to charge made, which follows which?
No, the investigation can both be internal or external. It does not have to be external. So
Okay.
normally,
Fair enough. Whether it's internal or external, which one precedes which?
is the investigation first, which will confirm whether the allegations are substantiated or not.
Okay, good. Okay, so then step 4 or 5 in my sequence would then be the investigation. Let's not qualify it whether it's external or internal. So there'll be the investigation, and then let's say there'll then be the decision to charge. Let's assume the investigation again says there's enough wrongdoing, correct?
Correct.
Thank you. And then once that decision is made, again, depending on the seniority of the person or the seriousness of the charge, then it would be referred to an external person to chair the DC, whether it's an advocate or an attorney or somebody like that. Or let me put it like this. Again, that may be external or internal. Let's just say a chairperson would be appointed, correct?
Yes, correct.
Okay, and only then as step 7 in that chain, if you are found guilty by that chairperson, then you whatever happens will happen, correct?
Yes.
All right. And this is just in relation to the case of Ms. Mukhaladi and the other persons. As an HR person, you know that once again we go back to this issue of there's the issue of the week of whether a recommendation is binding or not binding. So a chairperson, the external chairperson cannot fire anyone. They only make a recommendation, correct?
Yeah, that was the issue with our disciplinary hearing, because our disciplinary hearing says that he makes a final decision which must be implemented.
Yes, and the code.
The code, yes.
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 Right, but in the case of these 2 ladies and 1 gentleman, I think, who has since deceased, the chairperson had explicitly said that he was making a recommendation, correct?
That's correct, yes.
Yes. And as you know, or should know, or well, everyone should know, a recommendation in those terms then eventually depends on the actual decision maker to approve or disapprove, correct?
That's correct.
Thank you. And of course, they can't just say we don't approve or disapprove. There must be a reasonable basis. They have to give reasons, correct?
That's correct, yes.
And in this case, according to you, the reasons that the public protector had made for not accepting or rejecting the recommendation was, you said, the seriousness of the charges. And you didn't mention this one, but I'm just asking you, just from your memory, there was also the issue of the breakdown in the relationship, correct?
Okay, I can't remember that one.
I can't remember the second one. That's fine. That's fine. No, the documents will show. But in any event, the point is that the public protector gave her reasons why she was not accepting the recommendation, correct?
Yes, except that our code, as I said, did not make provision for that.
No, that's not what I'm asking you. Did the public protector give her reasons for not accepting the recommendation?
Yes, she did.
Yes. Your code, we know what it says. I think it's part of the documentation. But you and I have, I thought we had agreed that despite the code, the chairperson in that particular case had specifically couched his, I think it was a man, his finding as a recommendation, correct?
That's correct, yes.
Yeah. All right.
Mpofu?
Yes, Chairperson.
Maybe before you look for the next questions, can we pause there and take a lunch break? We'll be back at 2. Thank you very much.
Okay.
Recording stopped.
Okay.
The recording has stopped.
Okay. Thank you.
Okay. Chairperson?
Yes, you wanted to say something?
Yeah, I just wanted to check with your permission and maybe that of the members, if we can come back quicker than 2 o'clock, because I'm really not going to be long.
Quicker is what, 1:45?
1:45 or even 1:30, maybe, to be fair. Yeah.
Okay, we'll push for 1:45. Thank you.
Thank you, Chair. Thank you, Chair.
We'll work towards 1:45. Let's take a lunch break, back at 1:45.
Thanks, Chair.